For many watchers, day 2 of the cross-examination was expected to be nothing but spectacular, and so it turned out. But the court had to first issue strict instructions on the media conduct of counsel in the matter.
38. No, 38. Sorry. The court is not comfortable with the post-trial interview that you grant outside. We are just drawing your attention to the ethical infractions, and you have to advise yourself accordingly.
Now the real business of the day kick-started.
In respect of the issue of admissibility of the evidence in the video recording, our view is that at this stage we will only play the video recording for purposes of identification.
Lead counsel for the petitioner, Asiedu Nketiah, however, had objections.
Our concern is that it's not an issue of admissibility. And my lords, this was why I needed to clarify your last order, because
the admissibility comes first. It must be admitted before we see the relevance.
In that event, we are objecting to the admissibility. In that event, if the issue of admissibility.
With the objection noted, the court went on to review the electronic evidence.
Has won 141. That puts us in a clear majority, and will be given President Mahama the needed majority in Parliament to be able to conduct his business as president.
The petitioner's star witness insisted on clarity.
I stand by every word, every punctuation, every sentence that relates to me, Johnson Asiedu Nketiah. And there is nowhere, unless we are watching different clips, there's nowhere where I indicated definitively that the first respondent has won the elections.
For the second respondent, the crux of the petitioner's case rested on the 9th December declaration by the chairperson of the first respondent. Again, the petitioner's star witness, Johnson Asiedu Nketiah, had the responses.
We did not come to court to come and take over the work of Electoral Commission, but we are entitled, if we see the results are flawed, they are not born out of the data, we are entitled to challenge and to insist that we must have a credible result, that and a declaration that is based on the votes that were cast at the polling stations.
That's okay. I'm saying that you have not provided any basis of your own for your call for a runoff.
That's no, my lord, we haven't brought that data here. We didn't consider it necessary to our case to bring any such data here.
You see, do you know why you haven't brought any such document? It is because all the documents you have, all the authentic documents on the election that you have, show that the second respondent had won the election, so you can't bring it out.
That is not so, my lord.
The second respondent's lawyers maintained that all tabulations indeed supported the validity of the December 9, 2020 presidential declaration.
And 93 from the total valid votes obtained by second respondent, whether as announced in the declaration on 9th December or in the press release of 10th December, or when you add in all these occasions, the second respondent still obtains over 50% plus.
My Lord, here again we are attempting to take mangoes from apples.
Now,
Yet again, the petitioner's star witness believed otherwise.
My Lord, I disagree.
have you produced any evidence to the contrary?
My Lord, I indicated that we are here with the figures as declared by the first respondent. And we are questioning the internal consistencies of the figures.
You have not answered my question. I'm saying, have you produced any contrary evidence of the total number of valid votes that the second respondent obtained, showing that he obtained votes below the 50%? Have you?
My Lord, because those figures are not available.
The bench also had questions for the star witness.
My Lord, I haven't brought that figure to court.
Okay. Then, from your own calculations, what were the valid votes cast in favor of the petitioner, to your knowledge?
My Lord, when we discovered this discrepancy, it was difficult to even know which figures are.
You don't know. You just answer. You don't know.
I don't have them here.
Okay. Then the last one. What figures from your own calculations did the second respondent get as the total valid votes cast in his favor?
My Lord, I don't have those figures here.
Thank you. That's what.
The day wasn't all law in court. There were the light moments as well.
Yes.
Who in Ghana doesn't know the role you have played?
Yes,
Yes.
my Lord.
That was why he is trying to cross-examine you. Don't try to, go wayward as if you are engaging him.
Yes, my Lord, we are all learning. So, and in fact, my lords, if you permit me, in all the 7 parliamentary and presidential elections that have been held in this country before this one, the presidential candidate and the political party which wins and controls parliament ends up winning the presidency.
Please,
so
Mr.
I have...
Mr. Asiedu Nketiah, don't lecture us. You answer the questions I put to you. You can't lecture us here.
It's off record. You didn't tell us your other name. You did not tell us your other name. Your alias, which begins with the rank in the army. You didn't tell us your alias, which begins with the rank in the army.
I'm known as General Mosquito. Alias.
For now, the court stands adjourned.
We are of the view that it's been a good day in court and that today the big word is exposed. Exposed. You'll notice that counsel on our side spent a lot of time exposing the inconsistencies and sometimes even outright falsehoods that have been put out by the petitioner and the witness who was in the witness box today. So when you juxtapose the earlier claims of we won now to what they are saying in the witness box about they don't know who won, when you juxtapose that to some of the tapes we played about claims of 51% on their side, now to claims that they did not even bring numbers to court, if you juxtapose that between their petition that talks about vote padding of a certain number and now a claim that it's only samples of that number, one of the first things that counsel on our side sought to do today was to expose the inconsistencies and sometimes outright falsehoods that have been peddled by the petitioner and the witness who was in the witness box today. Our counsel also spent a lot of time exposing the bad faith and prejudice with which the petitioner and his team have approached the work of the Electoral Commission and the chair of the Electoral Commission, ab initio. And that's why you saw them take time to set out right from her appointment, from registration, etc. And the belief on our side that this is just a culmination of the various attempts to undermine an otherwise very good job that has been done. Also exposed through very vigorous cross-examination is a claim that was being made that nobody actually won this election. And that's why you saw the Venerable Akoto Ampao over and over again now raise the numbers and ask the witness to do the computation. And if you fry it, you bake it, you turn it upside down, you cook it, it is still 51% plus for the second respondent and about 47% for the petitioner. And you saw him do the maths and admit himself in the witness box when he was under oath. What we also found interesting were the attempts to shield the witness by his counsel to an extent that even materials that they had tendered in, there was an attempt to ensure that he was not questioned on it, even at re-examination, attempt to adduce fresh evidence. But I think you saw how the court handled it. The very final exposure we saw today, an exposure on the lack of candor. You heard the three questions that the bench asked. That for all that you have said, when you finished your collation, what were your results? When you finished your collation, what were the results that the petitioner got? When you finished your collation, what were the results that the second respondent got? And it was, I believe it will be very surprising to the millions of NDC supporters across the country who were egged on by the same team that they had numbers to prove they had won. Now here in court, when the bench asked those questions, they say that they did not come to court with any of those numbers. They are not still able to put any numbers before the court, despite all that they had said.
We are extremely satisfied with the testimony given by our General Secretary today. In fact, nothing that he has said undermines our case. Indeed, everything he said goes to points to the fact that we are entitled to the declarations that we are seeking. But several interesting things stood out today. Let me start with the video. The video that they sought to show to try and dent the credibility of the General Secretary didn't happen as they thought it would. In the end, his credibility rather soared. If you watch the video, and I'm sure you all watched it, it is clear from the video that he never said at any point in time that the petitioner had won the elections. In fact, what he did were projections, and rightly so. He stated that based on the 141 parliamentary seats that we had won, the projection was that we would win the presidential slot as well. Those were projections he made. And so they were unable to show from the video that the general said what it is they were trying to prove. So of course they flopped in that regard. The other thing that came out clearly was that there were ever-changing figures from the general's testimony. Now, from their own cross-examination, they describe these ever-changing figures as manifestly erroneous. We had the 9th December figures of 13,434,574, 10th December 13,119,460. Then in their paragraph 24 of their answer, that's the first respondent's answer, she talks about 13,121,111. Yet again, today, there were corrections made. And we saw that from the cross-examination on Techiman South. On the face of that, their own exhibit, it showed 97,227. But when they did the tally or the collation, it was 99,436. So when we make the point that based on their own declarations, that's the EC's own declarations, there are errors, we are right. and it has been proven by the cross-examination that they conducted that we do not know what the figures are. Based on her own declaration, nobody got more than 50%. And the declaration I'm talking about is the 9th of December declaration. Also important is the issue of padding. They cross-examined the general on the issue of padding. And you can sense from the cross-examination that they admit that there was padding. What they tried to portray was that on a pen drive, there was an indication that there was also padding in favor of the NDC. Now, if they admit that there was padding, then obviously we are dealing with a very flawed election. That is the point, and they admit it. It's a clear admission of a flawed election. And he also made the point that what we attached in terms of padding were only samples. Only samples. So you can't take a sample and deduct it from a whole or an absolute number and get any results, because that sample is simply what it is, a sample.